Taylor Frankie Paul's two former partners have issued a rare joint response after Utah's Division of Child and Family Services asked a juvenile court to make a serious finding involving her three children. Through their attorney, Dakota Mortensen and Tate Paul said they were deeply concerned and argued that Taylor's initial response minimized the gravity of the petition. But the most important fact is also the detail most likely to disappear in a headline. DCFS has asked the court to find the children abused, neglected, or dependent. The court has not yet publicly been reported to have made that finding. So what exactly is DCFS requesting? What are all three parents saying? And how could the case change the custody disputes already unfolding in Utah? For verified entertainment updates without the rumors, subscribe to Startline Entertainment. The latest development arrived on July 17, 2026, when attorney Chad Shattuck released a statement on behalf of both Dakota and Tate. The two men have separate parenting relationships with Taylor. Dakota is the father of her youngest child, while Tate is her former husband and the father of her two older children. Their attorney said both men believe Taylor's public response understated the seriousness of the state's action. He emphasized that DCFS had requested an expedited hearing concerning the children's immediate protection. Shattuck described the filing as more than an ordinary change of venue from district court to juvenile court. His statement said Dakota and Tate wanted better coordination among family courts, law enforcement, prosecutors, and child welfare agencies. It also said both men had largely avoided publicly answering accusations because they wanted to protect the children, adding that they intended to tell their stories in an appropriate forum when the time was right. Those statements represent the father's position through their attorney. They are not independent court findings about Taylor's conduct. Taylor's attorney had offered a very different interpretation after the petition became public. Her legal team described the move into juvenile court as a step that can occur in highly contentious and complex custody cases. The statement said Taylor welcomed additional structure and oversight, remained committed to restoring a more normal custody arrangement, and intended to continue working toward better health and stability. Her attorney also expressed appreciation for the professionalism of the DCFS representatives involved. That is the first major tension in the story. Taylor's side describes the juvenile court process as added structure that could support progress. Dakota and Tate's side says that description minimizes a petition seeking findings of abuse, neglect, or dependency. Both statements are public advocacy by adults involved in an ongoing case. Neither one tells viewers what the judge will ultimately determine. The petition itself was filed by the Utah Attorney General's office on behalf of DCFS during the week of July 13th. According to the filing reviewed by People, the agency asked the juvenile court to find that the three children are abused, neglected, or dependent, place the family under protective supervision, and appoint a guardian ad litem to represent the children. DCFS also requested an expedited hearing. Those terms require careful explanation. A petition is the document that places the allegations and requested remedies before the court. It does not automatically establish that every allegation in the filing is true. Under Utah's juvenile court rules, abuse, neglect, and dependency allegations generally must be supported by clear and convincing evidence before the court makes the relevant finding. That burden is different from the beyond a reasonable doubt standard used in criminal prosecutions, but it still requires evidence and a judicial decision. Protective supervision also does not automatically mean that DCFS is requesting the permanent removal of the children or termination of parental rights. Utah law defines protective supervision as a court-created status after an abuse, neglect, or dependency adjudication in which a child may remain at home while a designated agency provides supervision and assistance intended to correct the underlying concerns. The court can consider other dispositions depending on the evidence, but the specific phrase itself should not be translated into Taylor has permanently lost custody. The requested guardian ad litem would not serve as another lawyer for Taylor, Dakota, or Tate. Utah's Office of Guardian Ad Litem explains that its attorneys represent the best interest of children in juvenile cases involving alleged abuse, neglect, and dependency. The office also notes that state intervention does not always mean foster care. Many children remain safely at home while families participate in court-ordered services. That distinction changes the meaning of the latest headlines. DCFS is asking for a formal child welfare case with independent representation for the children and continued court oversight. It is not publicly reported as a final order declaring Taylor guilty of a crime, terminating her rights, or permanently transferring all custody. The agency's petition reportedly describes concerns about Taylor's participation in an existing child and family plan, her engagement with treatment, and her reactions during meetings or home visits. One adult-focused allegation says she left her home during a DCFS visit after becoming upset, requiring agency representatives to secure the residence. The filing also contains statements attributed to a therapist and DCFS personnel concerning Taylor's investment in treatment and her willingness to accept responsibility for conflict with Dakota. Every one of those points remains an allegation offered in support of the petition unless it is admitted, stipulated to, or proved in court. Because minors are involved, the most intrusive passages in the petition are not necessary to explain the legal development. The central public issue is that DCFS says its observations and records justify protective supervision and an expedited hearing. Taylor is entitled to respond to those claims, challenge the evidence, and present evidence concerning the conduct of the other adults. A source connected to Taylor told People that the public release of juvenile court material undermined the privacy the process is supposed to protect. The source also claimed that the reporting omitted DCFS concerns involving other parties that appear in district court and law enforcement records. Public material reviewed for this report does not establish the full content or disposition of those alleged concerns, so they should not be treated as confirmed findings against Dakota or Tate. There is also a technical correction worth making about juvenile court secrecy. Taylor's source characterized juvenile court as private. Utah Court's official public access guidance says abuse, neglect, and dependency hearings are generally considered open unless the court grants a motion restricting access. That does not mean every record or private detail involving a child is freely available, and a judge can limit access to protect the children. The safest description is that juvenile proceedings include significant privacy protections, while public access can vary according to the type of record and the court's orders. The DCFS petition did not emerge in isolation. Taylor and Dakota have spent months in overlapping custody, protective order, and law enforcement proceedings. On April 30th, a Utah court granted protective orders requiring both Taylor and Dakota to remain at least 100 feet away from each other. The commissioner said the evidence convinced him that their encounters could become violent and expressed concern about their ability to co-parent safely. Those civil protective orders were entered against both adults, not Taylor alone. The two sides have made competing allegations of violence, stalking, and injury. Taylor has accused Dakota of abusive conduct, while Dakota has submitted photographs and other material that he says show injuries caused during their altercations. The existence of those allegations does not resolve which account is accurate in every disputed incident. The mutual protective orders demonstrate that the court identified a need to keep the two adults apart while they continue sharing parental responsibilities. The criminal and child welfare tracks must also remain separate. In April, the Salt Lake County District Attorney's Office declined to file new charges against Taylor after reviewing two more recent domestic violence investigations submitted by Draper West Jordan Police. Prosecutors said the available evidence was insufficient for new criminal charges. That decision does not prevent DCFS from bringing a civil child welfare petition, because the agencies operate under different legal standards and address different questions. Taylor also has an older criminal case connected to a 2023 altercation with Dakota. She previously entered a guilty plea in abeyance to aggravated assault, while other charges were dismissed under the agreement. A plea in abeyance is not the same as a new conviction arising from the 2026 allegations. The older case remains part of the history cited in the custody and child welfare disputes, but it should not be merged with every later accusation. A major turn came only 5 days before the DCFS petition. During a July 8th custody hearing concerning Taylor and Dakota's youngest child, the court expanded Taylor's parenting time to include alternating weekends through Monday morning, along with the same midweek day each week without an overnight. The judge also ordered that the child be transported only in an enclosed vehicle with age-appropriate safety protections after learning that Dakota had used a motorcycle during a custody exchange. That order matters because the custody court had just increased Taylor's time before DCFS sought juvenile court intervention involving all three children. It does not necessarily mean the two decisions conflict. The district court commissioner made a custody ruling based on the evidence then before him, while DCFS subsequently filed a broader petition asking the juvenile court to consider its investigation and requested protections. The new court will have to decide how the cases and orders interact. Tate's position has a separate procedural history. He filed for a temporary restraining order involving his 2 children on June 30th, but a commissioner declined to grant emergency relief the next day. Reporting on that ruling said the court found no sufficient showing of immediate and irreparable harm at that stage. That denial did not prevent DCFS from later including the 2 older children in its statewide child welfare petition, and it did not decide the evidence now presented by the agency. The result is a complicated legal picture rather than one simple custody decision. Taylor and Dakota are subject to mutual protective orders. Taylor's parent time with their youngest child had recently been expanded. Tate's emergency restraining order request was denied. Prosecutors declined new criminal charges related to 2 recent investigations. And now DCFS is asking a juvenile judge to examine the circumstances involving all 3 children under child welfare law. This is why the July 17th joint statement matters. Dakota and Tate are not merely commenting as former romantic partners. Each is a parent whose custody arrangements could be affected by the juvenile court case. Their attorney's language suggests they want the court and multiple public agencies to examine the family's circumstances together rather than treating the disputes as isolated events. But their shared concern should not be interpreted as proof that all accusations against Taylor are established. Nor should Taylor's stated willingness to accept oversight be treated as a concession that the petition's allegations are true. Attorneys often frame the same procedural event differently because their clients have different interests and factual positions. The next meaningful development should come from the juvenile court rather than social media. An expedited hearing could address temporary protections, representation for the children, services, supervision, and how existing district court custody orders will operate while the petition is pending. The court may receive evidence from DCFS, the parents, therapists, investigators, and other relevant witnesses. Because the case concerns minors, the extent of public access to that evidence may be limited by court order and privacy law. The appointment of a guardian ad litem would give the children an attorney focused on their best interests rather than on defending any one adult. That lawyer may review records, speak with relevant professionals, and make recommendations to the court. The guardian's position will not necessarily match Taylor's, Dakota's, or Tate's preferred outcome. The television consequences are secondary, but still explain why this has become national entertainment news. Taylor is known through Hulu's The Secret Lives of Mormon Wives, and her family disputes have already affected filming and the planned release of her completed season of The Bachelorette. The child welfare petition now shifts attention away from reality television conflict and toward a formal legal process that should be covered with significantly greater restraint. No responsible report should package the children as characters in a celebrity scandal. Their names, reactions, and private therapeutic information are not necessary for viewers to understand what DCFS is requesting. The legitimate public questions concern the state's allegations, the parents' responses, the legal standard, the existing court orders, and what the juvenile judge decides next. Here is the Startline Takeaway. What changed is that Utah's Child Welfare Agency has asked a juvenile court to take a more direct role across the custody disputes involving Taylor Frankie Paul's 3 children. Dakota Mortensen and Tate Paul responded together, saying they believe the filing is extremely serious and should not be characterized as a routine transfer. Taylor's attorney says she welcomes the additional structure and is committed to complying with the process. What viewers should not assume is that the petition itself proves abuse or guarantees that the children will be removed. DCFS must present its case, the parents can respond, and the court must make findings under the applicable evidentiary standard. Protective supervision can allow children to remain at home while services and monitoring continue. The timing matters because the petition came shortly after Taylor received expanded parenting time in one district court case. It also follows mutual protective orders between Taylor and Dakota, the denial of Tate's emergency restraining order request, and prosecutors' decision not to file new criminal charges in 2 recent investigations. None of those earlier rulings automatically decides the juvenile case. Each involved a different request, evidentiary record, or legal standard. The clearest verified summary is this. On behalf of DCFS, the Utah Attorney General's office filed a petition asking a juvenile court to find Frankie Paul's children abused, neglected, or dependent, impose protective supervision, appoint a guardian ad litem, and hold an expedited hearing. Taylor's lawyer says she welcomes oversight and remains committed to progress. Dakota and Tate's lawyer says the fathers are deeply concerned and believe her response minimizes the seriousness of the filing. No final adjudication on the petition has been publicly reported as of July 17, 2026. The next answer will not come from another Instagram argument or reality show episode. It will come when the juvenile court decides what the state has proved, which protections are necessary, and how 3 parents with sharply different accounts will be required to move forward while placing the children's interests first.